Good evening, and welcome once again to Your Legal Rights on KALW 91.7 FM in San Francisco. I'm the host of Your Legal Rights, Jeff Hayden. In California and across America, thousands of people who are charged with criminal offenses are held in custody while awaiting trial. Traditionally, people got out of jail only when they made bail. That is, when they put up a lot of money or had a bail bondsman put up a lot of money to ensure that they would appear in court to answer for the charges against them. But here in California, legislators and the court, for the first time, are saying that this isn't fair. The size of your bank account shouldn't, they say, determine whether you sit in jail or go home while awaiting trial. Two bills before the state legislature now propose setting bail for most offenses at zero. Is this a good idea, or are we just giving criminals a get-out-of-jail-free card? Public safety, the rights of the accused, and maybe even your own freedom could be at stake. So let us hear from you, your thoughts, your experiences, and your concerns. Give us a call at 415-841-4134. Again, 415-841-4134. If you're outside of the Bay Area, call us toll-free at 866-798-8255. That's 866-798-8255. As always, our attorney guests cannot give you specific legal advice, as we don't have all of the salient facts of your situation. We're happy to share legal principles to help guide your decision-making, or maybe direct you where you can find some help. You can contact us with any question of bail or preventative detention or your right to a fair trial. You're not limited to the point where we may be in our conversation. To guide us through this examination of these vital issues, Jeffrey Clayton is the executive director of the American Bail Coalition. Mr. Clayton has worked as a public policy and government relations professional and also as a licensed attorney, serving a variety of clients in legal, legislative, and policy matters. Mr. Clayton also worked in government service, representing the Colorado Judicial Branch and State Labor Department and the U.S. Department of Transportation. He is also a prior Presidential Management Fellow and finalist for the U.S. Supreme Court Fellows Program. Dean Johnson is a practicing attorney, an Emmy-nominated legal and political analyst, and founder of Pundit Network, a social media network that uses the wisdom of the crowds to forecast the news. Scott Sherman is the managing attorney for the Private Defender Program of the San Mateo County Bar Association. Previously, Scott practiced as part of the New Orleans Public Defender's Office. After 6 years of trying difficult cases, he transitioned into management and enjoyed sharing the experiences and insights he gained from trial work with those that he supervised. Scott, Dean, Jeff, welcome to Your Legal Rights.
Hey, Jeff, great to be here.
Thank you.
So, Scott or Dean, could one of you give us a run-through? What happens when someone's arrested? I mean, how often are they held in custody and for how long?
Well, very quickly, I imagine some of our listeners aren't familiar with the bail system, but the truth is when you're arrested and or charged with a crime, you can be held in custody in the county jail until your case is decided. The only way to get out of jail prior to your trial is to have a judge release you on your own recognizance, which is these days the exception rather than the rule, or, as you said at the beginning of the program, to make bail. And making bail consists of giving a deposit of money to the government as insurance that you're going to show up in court. And if you do that, then you're released from custody. The alternative to putting down your own money, which can be a substantial sum of money, is to go to a bail bondsman. And bail bondsman will, for a certain fee, usually about 10% of whatever the bail is, write a bond and deposit that with the government. And they become the person who's at risk for your appearance, and that becomes insurance for your appearance. Bail bonds can be very expensive because bail is very expensive. Bail can run anywhere from $2,500 to hundreds of thousands of dollars, depending on the nature of the crime. And the fact is that that it's kind of a mechanical schedule. by which bail is decided in court, and how much bail that you have to put up is decided, and it's a function of the crimes with which you're charged. All of that has now been called into question, starting in 2019 with a case called In re Humphreys. And Scott, maybe you could pick up there.
Sure. So in 2019, after the Public Defender's Office in San Francisco challenged the bail schedule based upon a man who was unable to afford bail, the California, well, first the appellate court and then more recently the Supreme Court said that a lack of money alone is not a legitimate reason to keep somebody in jail, right? This shouldn't be about rich people getting out on bail and poor people not getting out on bail only because of money. So the Supreme Court of California, requires the superior courts, the trial judges around California, to look at other factors, the ability of the defendant to pay, and to look for other factors in addition to that, which could guarantee or help guarantee that the accused will return to court and not be a risk to public safety. That would be things like wearing an ankle monitor. It could be receiving alcohol or drug treatment. It could be checking in with a pretrial probation officer who can assure that the person knows their court dates and can show up. And really to look at things besides just money to accomplish this. One thing I also wanted to add to what Dean was saying is that traditionally with bail, when the deposit is made with the government, the accused would get that money back at the end of the case when the case was resolved. With a bail bond company, the accused will make that payment. It will have a contract with the bail bond company, and the bail bond company will put down will submit the surety bond, and the accused will never get that money back, even if the accused makes all of his or her court dates.
Yeah, and just to complete the history a little bit, there was something else going on as Humphrey was making its way through the courts. The legislature had also started to question the cash bail system, and there was a bill called SB10 that was eventually acted into law. And what it did was eliminate cash bail altogether. And the plan had kind of a science fiction tinge to it. What the legislature proposed was that there be a computer-based algorithm that would determine a particular defendant's level of risk. And based on the level of risk, you would either be incarcerated during the time that your case was pending, which could be months or sometimes years, or you would be released. And the cash bail was there only as some sort of last resort, if at all. This was the point where it became very political. The bail bond industry said, wait a minute, if we have no more cash bail, we're not going to be writing any more premiums. Our industry could potentially be wiped out. That led to the forming of what was a very unusual political coalition between the bail bond industry and people who essentially wanted to wipe out incarceration and the criminal justice system altogether. And the bail bond industry, of course, had its own economic interests. People out on the far left of criminal justice jurisprudence, I think, were, to coin a phrase, freaked out by the idea that a computer algorithm would determine whether somebody stayed in jail or not, and the totalitarian implications of that bothered a lot of people. And eventually Prop 25 was put on the ballot, and the voters agreed with that coalition and said, no, this SB10 is a little too bizarre for us. We would prefer to have the old system rather than this new system. And that was the point at which we stood until COVID-19 came along.
Well, I'm going to jump in and add a little bit. I'm going to give you a chance to respond, Jeff. You haven't been heard yet. But when you looked at SB 10, the judge had the absolute ability to say thumbs up or thumbs down. And if your case came up in front of the wrong judge or on a bad day or didn't like the way the facts were played out by the prosecutor before anybody else had seen any of the reports, the judge decided you're in. You can't post bail. Bail has always been available as a safety net in the past, as a way to get out. And people that were opposing SB10 weren't just the bail bonds industry, and it wasn't just the far left, but also people who didn't want that absolute control. I think the consensus was you needed some reform, but that's throwing out the baby with the bathwater. Before I turn to you, Jeff, let me take this call from Beverly. Beverly, welcome to Your Legal Rights.
Yeah, hi. I've obtained a post office box that is 1.5 feet off the ground. I can't change it. And I have documented permanent back damage. A year ago, the postal clerks were prohibited or barred from being able to accommodate me by, it's a random assignment of something around my height so I don't have to bend down. And isn't that a disability rights violation? I mean, I can see somebody with a wheelchair being assigned a post office box 5 feet off the ground, and they can't change him. The clerks can't change him. I don't know why it changed a year ago.
Well, you're a little bit off topic of what we're discussing tonight. I know I said you don't have to jump into the conversation exactly where we were, but you have people that either practice in criminal law or in helping to have people released while their case is pending so that they can better defend themselves. And it's really a different topic. Where are you calling from?
Sonoma, California.
You might try to see if the Sonoma County Bar Association has a lawyer referral service. Okay. I know Marin has reached through San Francisco, the Bar Association of San Francisco, and San Mateo and Northern Santa Clara are out of San Mateo County. Virtually every area in the Bay Area is serviced by a lawyer referral service, and they all have low cost referrals. Somebody that could talk to you and give you advice, maybe help find a solution for you.
Beverly, I have one more suggestion for you. There is a very active bar now of American Disability Act plaintiffs' lawyers, and you sound like you're a potential plaintiff. Go to Google and just look that up, American Disability Act attorneys in your area. I'm sure you'll find somebody. Those people are very, very active litigators and very effective at what they do.
Well, I don't have much money. Is there any agency I can write with a complaint?
They'll do it on a contingent fee. If they don't get paid, you don't have to pay them.
And the lawyer referral services also tend to give you a consultation for a very small amount of money. Usually, they have some provision for low-income people to even waive that.
Okay, very good. All right, thank you very much for your help.
Thank you.
Good luck to you.
And thank you for joining us on Your Legal Rights. Okay. Jeff, before I turn it back to you, and I want to give you a chance to respond, before we move on, I do want to bring up the Humphrey case, the current incarnation of the Humphreys case with the Supreme Court's opinion. But given our discussion of first SB10 and then Prop 25, I wanted to give you a chance to respond.
Yeah, absolutely. I think, the right to bail in California is enshrined in Article 1, Section 12 of the Constitution, the right to bail by sufficient sureties, which we know means money and has since it's been in the Constitution and before statehood. Interestingly, the first bail shop in the United States was operated in San Francisco, the Old Lady on Kearny Street, which I believe opened somewhere around 1879. As Professor Freed said, in those days, we were the true friend of the friendless, the bail industry, at helping people exercise their right to a personal surety. In terms of the Humphrey decision, I think the California Supreme Court followed the lead of Justice Hardesty in Nevada to say that we're going to take the elements of preventative detention and we're going to mix it in this no money bail system because we have a constitution that says right to bail by sufficient sureties. And then we have this idea that we don't want people to be held on what we would call sub rosa detention. In the overview, you said for the first time the California legislature or somebody has objected to this concept of sub rosa detention, meaning that we set a high bond to keep somebody in jail intentionally. Dates back to the Four Knights case when Lord Coke defended the Four Knights for not wanting to contribute to the war effort and were preventively detained by the king. A couple of other points I'd make is that own recognizance is definitely the rule, not only in California, but nationally. Less than the majority of felony defendants ever post a monetary bond. And final point I guess I would make is that, the idea that we should allow the public to post 100% cash sounds good in concept because they get it all back. But what we see nationally, pressure and division in the case law, is that the government ultimately keeps all the cash and turns the bail system into a collection mechanism, which many states around the country have done and would be the risk of doing that and violate Stack versus Boyles, that we're setting bail to enrich the Treasury or to pay all these other programs rather than to guarantee the appearance in court. And if I could just make one more point, is that the U.S. Supreme Court decision in U.S. v. Salerno is the crossroads on bail, where we started predicting and using predictions of human future behavior to incorporate into bail. And prior to that, as Justice Marshall said, that was the decision that would go forth without authority and come back without respect. And we've seen that mass incarceration in a no money bail system in the federal system has tripled since 1984. And we don't want to copy that in California or anywhere else.
The question I've been curious, I remember learning in law school that the Eighth Amendment right to bail has never been truly incorporated to the states in a direct form. And we now have a Supreme Court that is made up of judicial conservatives who, in many cases, read the plain language of the law, of the Constitution, exactly what those words say. Is there any likelihood that sometime soon they're going to look at the systems of bail in various parts of the state and say, we actually do have a right to bail, plain and simple as it's written?
I think they have. There has been some case law on that. The reality is two things. One, state constitutions have one of two provisions. The provision is the excessive bail clause of the Eighth Amendment, so they don't need to incorporate it because it's already in the state constitution. Or they have the right to bail by sufficient sureties, which is more expansive than the Eighth Amendment right to bail, meaning that any reasonable defendant would argue their right to bail under the state constitution. So practically, it just never seems to happen.
I have a question. I think we're in a unique position here. We now have some pending legislation that talks about what is somewhat inaccurately called a zero bail system. But unlike many social policies, we've had an opportunity to experiment with that system. The part of the history that we didn't discuss was COVID-19. And during the COVID-19 period, the courts issued emergency bail schedules that provided that for almost all misdemeanors and most non-serious felonies, bail was zero. And people were literally walking out of pretrial detention without posting bond at all. And I'm wondering, can we draw any implications from that experiment? I mean, I've seen the sponsors of the current bill saying, hey, we've experimented now for a year and a half with zero bail without a lot of increase in crime or recidivism. I've seen other people say those people who got out on zero bail, about 55-60% of them committed new crimes. What's your, Jeff and Scott, what's your experience? How has this experiment worked out?
I'll say in San Mateo County, from what I've seen, so far it's worked out. I think it's worked out well as far as the commission of serious offenses, right? There's not, what we've seen is that, people get out, a lot of them come to court. It's been a bit confusing as far as the data, but overall I think it's worked in San Mateo County, that it's showing, and hopefully the judges are seeing and following, that having people released on zero bail, own recognizance, whatever it is, released without a financial obligation, has been working and has been working for the people in San Mateo County. It's been saving money on as far as the number of people who've been in jail, keeping our jail population low, and hopefully it's something that will continue to go on into the future, and the judges will appreciate that, and the district attorney's office will appreciate that.
I'd just say that I think the legislature doesn't have the power to set a zero bail. We learned that during the pandemic, but the Judicial Council didn't have the power to set a zero bail. They could set a zero bail schedule because we had a pandemic. I think the testimony reflected that judges learned from that in setting the annual bail schedule. They made changes because they learned a few things during the pandemic, and that many of the changes, a lot of the zero bail didn't go away. But what we did learn from a nonpartisan institute was that the reforms in San Francisco from 2015 to 2019 have resulted in a situation where 50% of defendants aren't showing up for trial.
You're listening to Your Legal Rights on KALW 91.7 FM. I'm your host, Jeff Hayden. Tonight, we're looking at a hot button issue, your right to bail. If you have questions for my guests, our phone number is 415-841-4134. Again, that's 415-841-4134. If you're outside of the Bay Area, call us toll-free at 866-798-8255. That's 866-798-8255. As always, you can call regarding any question on tonight's topics of bail, or even just ask what all this means to your right to be free of pretrial detention while your trial is pending, or even the related issues of public safety. You don't have to jump into the exact point we are in our conversation. So earlier, before we get to the current legislative scheme and what's going through the Assembly and Senate right now, we've mentioned the Humphreys case. We do have the final version of the Humphreys decisions that came from the Supreme Court. Who could talk a little bit about how that all panned out?
I could do that. Humphreys essentially says that it makes no sense to have a system of bail where a billionaire and a pauper pay the same bail, because money doesn't mean the same to a billionaire that it does to somebody who's on the streets and homeless. And so what the Humphreys decision says is that cash bail should be considered only as a last alternative. We need to look at all kinds of other alternatives, such as those that Scott listed earlier: electronic monitoring, GPS, home detention, contact with a pretrial services agent, before we consider cash bail. When the cash bail is considered, it ought to be proportional to the person's ability to pay. So judges have to consider your income, your ability to pay, your economic circumstances, and that, yes, you can hold somebody in custody without bail, but that, according to the Humphreys court, you can do only if it's absolutely necessary to protect the public safety and no other alternative will do. And if that's not a fair rendition of Humphreys, I'm sure you guys can tell me otherwise.
I think what I could add, what I would add is that Humphreys is not, in my opinion, a huge revelation by the court. It's been the law forever. But it's like they're finally sort of recognizing, oh, we're not supposed to keep somebody in jail just because they're poor. It's always supposed to have been doing that. And hopefully the judges will learn it. I think the downside of Humphreys, and I can say this from some anecdotal evidence in San Mateo County, is the downside of Humphreys is some judges discovered, oh, there's a provision in the Constitution which says I can hold somebody without bail. And it almost makes it, and I know that the district attorney's office has seized on that sometimes, and so have some of the judges. And that's been a negative in our jurisdiction with the Humphreys decision. They're reading it out of context. Instead of saying we are supposed to have fewer people in custody, only have the people who are necessary, who really need to be there, held in custody, we sort of just found ways to slide, I think, into the old familiar habits. And then with some added, a little bit added, hey, we can hold some people without bail. So there have been some negatives in at least locally in the implementation of the Humphreys decision. And
Jeff, you look like you have something on your mind.
Yeah, I would just add exactly what he's saying is we've taken the back door of sub rosa detention that we think is evil and made it the front door. And is that, a good outcome? Obviously, we left the bail schedule system in place that leads up to Humphrey, and the decision alludes to that. And I don't think this is landmark law. I think the real question that I've heard from staffers is when when are these hearings going to happen, and who's going to fund these hearings, and how robust are they going to be, because the courts don't want to do them and there's no money to do them, and all this sort of thing. I think what it came down to was over-reliance on the bail schedule, that we should have had a de novo hearing when they got in front of a judge. They didn't do that. They just deferred to it. It had to be de novo, and it wasn't. And I think this Humphreys decision is a good place. And what disappoints me is that the legislature's not taking that ball and running with it and saying, we're having Humphrey hearings in 48 hours. Because the Justice Hardesty in Nevada said, we're having Humphrey hearings at first appearance. And that would be a revolutionary change and would also be quite expensive.
Yeah, and during the interim period where the Humphreys appellate court decision was announced, and while the Supreme Court had it under review, we had some experiments with that, and that's exactly what happened. Is that you started having Humphreys hearings instead of judges just mechanically going down the bail schedule and saying, "Okay, you charged with a robbery, it's $50,000. I don't care if you're Bill Gates or you're Joe Blow from the street, it's $50,000." I think probably the main difference we're going to see is just that it's not going to be mechanical anymore, and that people are going to realize that, yeah, you've got to consider the accused's ability to pay. And that's, judges have always had that discretion. They've always had the discretion to deviate from the bail schedule. But and I know that you get on an arraignment calendar on a morning or an afternoon, and the law says the presumption is to schedule bail, and we got to move this case along because we've got 50 more cases on the calendar. So it's scheduled bail, and we'll see you in 2 months, and you can sit in jail until we see you again.
But I think the next question, though, is what the legislature is saying. After all, with $0 bail, are they saying, well, judges, you know what? You've had this discretion, you've had the bail schedules, and you failed. And since you failed on low-level misdemeanors, on low-level felonies, we're just going to, you failed on over and over and over again. You've kept the system of mass incarceration. We're just going to lessen the amount of discretion that you have. And I think that's part of what it is.
And we'll get to that momentarily, because we do have to break in a moment. I don't really want to open this can of worms right as we're about to break. But one question while we're still on Humphreys. I've heard from some sectors of the state that judges are using that provision where they can hold without bail as a deterrent to people running bail motions. Have we heard of any place locally where that's going on?
I can say that there's a fear of it, and that it is a fear by some San Mateo, some local practitioners of that.
As a practitioner, I can say that in the last few months, I've been writing bail motions right and left, and I've been surprised at the results, that actually we've been successful in getting people who were charged sometimes with very serious crimes out on a fairly reasonable bail where we would not have had a chance in the past.
Jeff, do you find that that's happening anywhere?
Well, I don't in specific, but I just remember a conversation I had with the late former public defender Jeff Adachi in San Francisco, who said, when I started this whole Humphrey hearing process, I was winning 1 out of 3 times, which means excessive bail was being set 1 out of 3 times. So we can all agree that that's a bad idea, and that lack of due process was a problem. Of course, everybody wants due process and more due process until they lose, and they want more judicial discretion until they lose. But, due process is the touchstone of what we need in California. We all knew it for many years, and I'm glad to finally see that day's arrived.
I'm curious, Jeff, and I don't know if you can answer this. Assuming that we have a Humphreys bail regime in the future, which appears to be the case, is that a good thing for the bail bond industry or a bad thing? I mean, it seems to me that you could argue that people when bail is on a sliding schedule, there are going to be a lot of people making bail who otherwise couldn't have in the past.
Well, we can't be in a situation where the benefit of posting bail is excessive bail has been set, and that we can profit off of that. And so to the extent that we can have bails set properly, that's what we want. And maybe that's lower, and that's fine. I think we've recognized that. Interestingly, the whole conversation about the bail schedule has not happened. The California Supreme Court noted that they're not deciding that. And so this whole regime that we have at the front end that's mostly statutory and that the legislature is debating right now will remain until some further conversation occurs on that.
You're listening to Your Legal Rights on KALW 91.7 FM. We'll be back right after this. So Our next stop, we've talked about Humphreys, we've talked about the history. Let's talk about what's in front of the legislature right now. We've seen several things that the legislature's looking at. We're looking at a statewide bail schedule. We're talking about lower bail. Who would like to take that on and talk about the pending stuff right now? Jeff, I see your finger in the air. It's to you.
Thanks. I've been involved in the California legislature for a very long time on this topic, so I know this bill intimately well. The first section sets zero bail. And you said for many offenses. I want to clarify that, there's very serious offenses that are not zero bail. We're talking about, not as serious offenses. And and it's hard to find which offenses are in and which offenses are out. But if you go read the offenses that are in, you got to think that most of the serious, offenses enter California. The bill attempts to codify the Humphrey decision by recognizing this right to what I guess would be called a reasonable, affordable bail, which I think would refer to the procedures in Humphrey, which I guess the legislature hasn't run with. And then the third section of the bill requires a refund in a couple of different circumstances when a bail premium for a bail bondsman who has posted a bond, when the defendant, when charges are not filed within 60 days, when the charges are dismissed, or when the defendant appears. And so that will create, flip the presumption of innocence on its head, because if we know the guy's provably guilty and isn't going to show up, we can bail him. But the reality is the bail model for bail agencies will fall apart under this bill. And I don't know that that's going to be the final landing point on this bill. But as it stands now, that would kind of, roll a Yahtzee on what the bail market would look like and what the bonds would be in California and whether defendants would be able to afford to get out. So those are kind of the three central components. In terms of the bail schedule, it's been assigned to the Judicial Council instead of local judges. So that's a major change, one that may be constitutional, may not be, we don't know, that the Judicial Council will take over. So local judges will no longer be setting the schedules in the jurisdiction. They'll be set by the Judicial Council of the state of California.
One thing that a lot of people don't realize is that bail is basically an insurance policy, ensuring that you're going to show up. And the whole premise is risk sharing. So does that not get turned on its head if charges are not filed? The person that would have been charged gets their money back, but everybody else has to pay, I would think, quite a bit more because they wouldn't have that risk sharing.
Guilt or innocence, yeah, absolutely. And guilt or innocence should not be the measure of bail, right? It should be, whether, you want to post full cash or make a contract with the bail agent. So absolutely, this is going to hamper the right to bail in California to use a personal surety. And for, how that'll shake out, would remain to be seen if this bill goes into effect as is.
Just a clarifying question, Jeff. I know there's a provision in one of the bills that says that you have to give the money back, but you get to keep 5%. Is that 5% of the premium or 5% of the total bail?
That's 5% of the premium charge, which really is not enough. And Senator Hertzberg in the hearing yesterday referred to this, reasonable rate of return in insurance, which is the law in California. And so I think that's what he's talking about is we have to reconcile these provisions and find a way where, when they get the wrong guy and they post a $500,000 bail, we have this. We've seen this in other states that there's rules on this. And I think that's the sweet spot of what we need to find in California is, we don't want somebody to have to post a major bail and pay bail bondsmen when they got the wrong guy. And of course, we'd like the state to pay for that, but we have governmental immunity in the way. And I brought that up, and there's no appetite to waive governmental immunity for wrongful acts of police or prosecutors right now.
So if somebody who's out on bail and buys a bond, does all the right things, you wind up with just 5% of 10% of the bail.
Right. And of course, at the front end, if they told us they were innocent and they were provably innocent beyond a reasonable doubt, we couldn't bail them. If they told us they were going to show up and we knew they were, we couldn't bail them because we would have to give everything back. If they told us they weren't going to show up and they were guilty, we could bail them. And that's just, we should not be mixing innocent and guilt with the right to bail. And I think that's a bad provision. I get you got the wrong guy. There's a windfall, unjust enrichment, and all of that. And I think that's the sweet spot we have to try to hit. And, we're looking forward to working with Senator Hertzberg, hopefully, on that point.
Well, and I do want to spell this out just to make sure people understand that that at this point, under the law, that when someone gets a bail bond, it's non-refundable, and they pay what they pay. And so if it's if it's a $75,000 bail, and they'll pay what? It was around, we'll say around 10%. Is that right, Jeff? Close enough, Jeff, for argument's sake?
Yeah.
All right, so they pay $7,500. Maybe it's an installment plan. Maybe it's all at once. But even if the person is provably innocent, and then they're not allowed to, they don't get any of that money back, right? And so, for instance, I had a client who was wrongfully accused, and we were able to prove it through video. He was wrongfully accused of a sex offense, an incredibly serious charge, and he had almost no money. He put everything he had into being free, and then he did a great effort by himself to go and get the videos necessary to help me show that he was innocent. And I think that's part of where there's a hole in our system, because he should never have been charged. He should never have been arrested. He should never have been paid. But he's still out that money regardless of what happens. And I think that is still an ongoing problem in our system that wouldn't be there if there was some type of deposit, system. But that's not on the table at this point. Well, yeah, deposit for smaller amounts than what bail is.
I think our listeners should understand how devastating this can be to somebody who's arrested for a crime. They're supposedly presumed innocent, but when somebody like Scott or myself goes into court to argue for bail, the law says that the judge is supposed to presume that all of the allegations in the prosecution's indictment or complaint are true. So instead of presuming innocence, we're presuming guilt for the purpose of setting bail. And we're talking about big chunks of money here. If a significant felony can result in a $50,000 bail. In fact, average bail in California for felonies is around $50,000. That means a 10% bond cost $5,000, and there are a number of studies that show that right now the average American is really in debt, that most American families couldn't afford an unexpected expense of $400 if it came up. So posting bail is really, really tough for a lot of people, and that's why there are 460,000 people in jail pre-trial at any given time in America.
Let me turn it over to Gloria on the phone. Gloria, welcome to Your Legal Rights.
Yes, hi. I just have a comment in having some experience in dealing with this, that, there are people who are, arrested and are incarcerated, and they have options of, choices. What do they want to do? Do they want to sit and wait until they see a judge? Or do they want the options of, one, putting up their property up with the court, which would take some time? Do they want to put the full amount of money up, which most of the time they can't? And or there also exists pretrial services. Pretrial services are there to determine, is this person a risk or will be coming back to court? So there are many options, and one of them, again, is then the bail. So, of course, they would sit and wait until that is determined if they qualify. But with bail, it is a choice that they make, and they decide and they understand the situation. So, I'm sure that in some cases people are wrongfully arrested, but if they stay, they will also have the same consequences of losing their opportunity of their job, or family, being alone if they're single. So it's a decision, and it's a right for them to have that option. And I know that we try to work through that. So it is one of those things that does need to have a discussion, but it exists. So it's not just that people are stuck in there and not able to have options of release, and people have the right to be proven innocent before guilty. So, that's where bail comes in for every person, and the opportunity. There are many options.
There are a lot of choices to be made along the way, and sometimes putting yourself in the best posture is really lining up in a particular case what's the best option for an individual. Sometimes people get arrested on what the police believe meet the criteria for a felony, and the prosecutor actually files a misdemeanor, and the amount of bail goes way down at arraignment. But that person who may be arrested on a Thursday or Friday going into a holiday weekend might not see a judge for 4 or 5 days.
Absolutely.
Beverly, I think you make a great point, and I am a huge advocate of expanding pretrial services. In the federal system, the presumption is that there will be no pretrial detention, that you'll get out while you're awaiting the adjudication of your case. And when you do get out, there is a whole office called pretrial services, and you have to go and interview with them, and they do a lot of things for you. First of all, they follow you around like a flea on a dog, and they monitor everything that you do. But for people who have mental health issues, drug issues, and things like that, they start the process of rehabilitation right there. Getting people into counseling, treatment programs, and that's all pre-trial, and that's all stuff that's in the interest of the defendant and in the interest of the public. And I think in the state of California, we do have some pre-trial services, but that really needs to be expanded as an alternative to cash bail.
I see Jeff trying to speak. Go ahead.
Yeah, I am. I would like to say a few things. I think the federal system, you're right to bail in the federal system. Once there was a presumption of bail, now there's not. We incarcerate 75% of all defendants in the federal system, 25% in 1984. That's not a good model. The trade-offs between bail and pretrial services we've seen, I think pretrial services set people up to fail. I think we've seen that. I think in San Francisco, when we went from a system, we reduced the use of monetary bail, but what we saw is that intensive supervision doubled from 14% to 28% of all defendants, which means that they are under conditions that they're probably going to violate. Other states allow defendants, in fact, to protect their liberty and file a bond, post a bond to get out of conditions. And so I think there has been evidence that this idea of using pretrial services and assuming people are guilty pre-trial has led to mass incarceration. The federal system is all the proof you need of that. When you eliminate the right to bail, you went to pretrial services, and you did all of this, you tripled pretrial incarceration from 24% in 1984 to 75% today. So I don't think states and localities can afford the federal system.
Yeah, certainly not my experience with the federal system. My most recent federal client was suicidal when he was taken into custody. Released on his own recognizance, got counseling treatment, is in that counseling and treatment today, and is probably alive just because of that. Also, the federal system has a thing called a signature bond, where you and or your partner or your family can show up, and instead of posting cash bail, you can promise to pay a certain amount if you don't show up. And that seems to work really well. It certainly worked well with my clients.
What I can add to this really is that pretrial release is perhaps or at least one of the most important predictors of the success for a defendant in their case. The results are better for people who are free. At this point, bail is a constitutional right in California, which I know is one of Jeff's points, and it is there as an important, I think, safety net at this point. And one of the problems that we have currently with I think that Dean talked about earlier, with the sort of predictive value of the algorithm of I think the instruments the risk assessment instruments that were used, was that they would use bad data. For instance, like prior interactions with law enforcement. So, somebody who grew up in a poor neighborhood and was a person of color and was subject to more likely harassment by police or law enforcement, well, they'd automatically get a lower score because of the systemic racism that we're trying to fight against. So there were still problems with that, while also problems, I think, with the bail industry. I think there's a good argument that the bail industry drives up the cost of some of the bail bonds, and it allows the judges to set bail high, and then it's up to folks whether or not to make bail, to try with a bail bondsman or not.
At one point on the cost of bail, if I could just say something real quick, is that Proposition 103 in California allowed for swept in the bail industry to premium rebating in California, which means any bail agent can rebate the entire premium. And that has over time had a trajectory of the increase in bails because the price per dollar of liability in California has gotten so low. Other states, for example, you have to have full premium or there's set premiums. In California, that's all kind of nebulous at this point, and we've seen over the last 20 years since that's passed an increase in the bail amounts in California, which I think needs to be fixed.
I mean, seriously, Jeff, how often does a bail bondsman rebate the premium? I mean, I've been doing this for about 30 years, and I've never seen that happen.
Oh, it happens every day, and the idea that people get 10% in California is not the rule. It's the exception. I don't know exactly what the percentages are, but we've seen bails posting 1%, 2%, 3% of the amount, and the market's so competitive in California per dollar of liability, and that's why the bonds, they appear this high. But if you took that bond to Colorado, for example, or some of the other states where it was 10%, it would be even worse than it is right now. So the bottom line is, we need truth in bail. Is what do people pay? The judges know, and then I think it'll come into a little bit better balance if we could go in that direction.
One of those things might be policing within the industry, where we have a situation now where there's larger bail companies that will come into an area, allow people to put next to nothing to get them to post bail. They'll post a tiny percentage of what the amount is. Ultimately, the person doesn't have any skin in the game. So the system is predisposed to fail, and the court's only response is to raise the bail schedule higher. So it is what you're saying. It's very cyclical.
A lot of states have a floor. You can't go below because it gets stupid at that point. And I think that, it's something to look at in California. You can't go below, Connecticut, you have to put 30% down. That's the rule. Other states, full premium, all this sort of thing. You got to try to collect on the amounts out of there. But it could be corrected. Certainly, I can't be the one to do it. Maybe we need to give Ricardo Lara the call.
There's a floor on the premium, but not a floor on what percentage you have to put up front.
There is a floor on what percentage you would have to put up front in states on the East Coast that you could, if the premium was 10%, you'd have to put 30% down to go on a payment plan at that point. And so other states have looked at this idea that we don't want it to be zero. We have to say it can't be below this level. And that's something maybe that California should take a look at.
Well, Beverly, I think we answered more questions than you asked us, but we've enjoyed having you with us. And thank you very much for joining us in Your Legal Rights.
Thank you.
I do have a question for you, Jeff. Why did people reject Proposition 25? Some folks may have been confused. I think a lot more of them may not have liked the idea that a computer was determining your fate, or the judges at some point wouldn't be able to go back to the floor of setting bail. But how did you read that?
Well, it's a two-pronged approach, and if you recall the days of Senate Bill 10, it had nothing to do with preventative detention or algorithms. Risk assessments were kind of in the bill, but the final bill that came out was pretty much risk-based preventative detention. We knew that preventative detention was suspect on the California Constitution because it laid out sort of, what had happened. But what we learned during the campaign was two things. People like the right to bail. They understand it. They want to keep it. Of course, they agree that, there's too much bail. The bails are too high. All the arguments that we make here, they agree with. But the number one thing they hated was the risk assessment. And I remember taking a Uber car to a bad neighborhood in a town I'm not going to say, and I talked to a group of African-American folks who said, we don't like this thing, and we're telling you, we think this is a smokescreen for mass incarceration, and we want you to go out and fight against it. And I have for many years, because I just don't think it works. Former Chief Justice I worked for said a risk assessment is merely a security blanket for judges to blame a bad decision on that rather than owning it. And so that's where we came down. But I think those were the two things. Really, the risk assessment, I think, is what got them.
You mentioned mass incarceration. Do you think bail reform would alleviate some of this mass incarceration?
It certainly could. And, we know that the outcomes are worse if you stay in jail. That's fact, and that's undeniable that, people will get a better deal if they're out of jail. What I can say is that the crossroads in U.S. Supreme Court history of allowing dangerousness and public safety considerations to mix with bail and turn Stack versus Boyle into something that it was not, which is bail was just supposed to guarantee appearance. That is the crossroads, and predictions of future dangerousness have led to mass incarceration in this country. That's undeniable, and bail is just a mere part of that. And using future dangerousness to set bail erodes the presumption of innocence more than anything I can come up with.
And that's been the law in California since Proposition 4, Proposition 8, back in 1980, thereabouts?
Yep, that's right.
So suppose we see your average person charged with a crime, and you have somebody like Jeff Bezos or Warren Buffett charged with a similar crime. Should they have should they face the same bail schedule, or should they pay significantly more, since to them there's no skin in the game?
Well, I'd argue they should pay significantly more, and we've seen this with some of these high-end guys that they're paying bails that are ridiculous. But let's just call it what it is. When you're a billionaire or you're multi-gazillionaire, you're going to be able to escape a lot of this stuff. But, we've seen, one of our bail companies paid a multi-million-dollar judgment on a guy who fled, and they thought they could track him and all this sort of thing. So the bail should definitely be higher for these guys. And, unfortunately, when you're at the top end, it's a little easier to get around this thing with a team of attorneys, F. Lee Bailey and Johnny Cochran, all these guys, than it is at the bottom end. But don't tell the San Francisco Public Defender's Office that.
I do think that one thing that can be looked at is that it's time for California to sort of look at, and this gets to the term skin in the game, which I think has been used a couple times. The original concept of bail was that someone would have skin in the game, have a reason to return to court, because at the end of their time in court, they would get some money back. I think that it's time for what I'd like to see out of California is California to start experimenting with that. Why? If someone has $200, $500, $300 that they're going to get back from the court if they keep showing up, maybe that's more of an incentive for someone to keep coming to court and fight their case than if they give the money away sort of to the bail bondsman when they're never going to come and they're never going to bring it back. And that's something we're not experimenting with. We're just going all the way to the sort of to the other end of things.
The point I would like to end with, I want to give each of you a chance to talk about this a little bit before I turn it over to you guys. We've had almost a year and a half with a very different situation due to COVID, and people getting released and who shows up and who doesn't. Have we learned lessons from that we should incorporate and make permanent in our system?
Yeah, I think we have. I can only speak from personal experience and what I see every day in court. I think we have learned that bail is set by the schedules, and cash bail in particular is excessive and often unnecessary. I have something that I've said many times on radio and TV, that a lot of my clients who are charged with criminal violations aren't criminal. They're people who were in the wrong place at the wrong time. And those people are often the people who can't make bail and who just sit in jail awaiting the adjudication of their case. And while they sit awaiting the adjudication of their case, they often lose jobs, they lose housing, they lose education, they lose family support, they lose health care. Sitting in jail, they lose all of their options and all of their alternatives in life. And recidivism for those people is much higher than that for people who do make bail while they're awaiting their case, the conclusion of their cases.
So what you're basically saying is, by removing the stability in their life, by throwing them in jail and giving them such a tremendous interruption in their life, we've taken away the supports that let them function. So in the end, they're no longer working for us, we're working for them.
Yeah, exactly. And during COVID, we had a huge social experiment with that. And I think though the jury's still out and the statistics aren't all available, it looks like that was a good social experiment. We learned that the bail we were setting was excessive, and when these people could get out and get on with their lives, they eventually took care of their cases, and then they were able to continue with their lives without the huge cost to society that pretrial detention entails.
Jeff, how do you feel about it? Do you see lessons that we should have taken away or should be taking away from the COVID experience?
Well, I think we learned that there are excessive bails being set in California. We learned that. But we also learned that when we over-rely on the charge to predict pretrial misconduct, we make a grave mistake. We learned that under a bail schedule. We learned that when we use the charge alone to predict pretrial misconduct, we make a big mistake. And we learned that there were some people under these charges that should have gotten out, and there were some people, that shouldn't. So I think what we learned is that individual consideration, what the California Supreme Court calls for, is the touchstone of what we need. An expanded due process will deliver better results in California.
Scott, I'm going to ask you the same question, but I want to throw another element to it. One of the things that we experienced during the COVID times are a statewide bail schedule that was imposed on us by the Supreme Court. Is that something we should bring into the mix?
Yeah, I think it is. I think that what we've learned from that is that we can go on with this bail schedule, with $0 bail, with reduced bail, with a reduced population in jail. And you know what? We're doing well. We're doing really well with this. And so we shouldn't go back. We should not go back to the times of mass incarceration, to a bail schedule that was set and thought of in times of mass incarceration. And we should turn a corner and not look back at failed policies of the past, that we should keep working towards that. And with that, things like the bail schedule, and that we should be looking for ways to, in California, to innovate. And not just to try to go to extremes, but to innovate, to make things better for people, so people can get out, can fight their cases when it's appropriate. Because you know what? That's how you can sort of level the playing field. So not just the rich are out, not just the people with money, but anybody who's charged with a crime does not absolutely need to be held in custody and be out and fighting their case.
We have about a minute total left. Each you want to spend about 30 seconds for any closing thoughts?
I'll go first. This is a huge problem. Pretrial detention results in about a third of the people who are subject to mass incarceration being in custody. About a quarter of all of our people who are in custody are detained pretrial and presumed innocent. There are so many alternatives available to cash bail now. It's time to make a system that integrates all of those innovations and all of those alternatives and makes cash bail the last resort for people who are sitting in jail presumed to be innocent.
Jeff, any closing thoughts?
Yeah, I mean, I think California needs bail reform. We all know that. Let's not make a mistake and do what Houston did and triple pretrial crime. The report just came out on Friday. In the last 4 years, pretrial crimes tripled. We don't want to do that. And I think we can find a solution in California that makes sense, reduces the impact of bail, reduces pretrial incarceration, has better outcomes. Let's get to work.
Scott, last words.
Yeah, we can do better. I think it's what everybody said. We can do better. We all know we can do better. As what Jeff said, it's what Dean said, and I'm saying it now. And I hope our legislators will look for ways, and that people will encourage them to look for alternatives that won't require bail bondsmen, that won't require, that will make bail do what it's supposed to. People show up back to court.
You've been listening to Your Legal Rights as we look to this issue of the right to bail, considerations of public safety, and pretrial detention. Our guests tonight have been Scott Sherman from the San Mateo County Bar Association's Private Defender Program, Dean Johnson of Redwood City, and Jeffrey Clayton, Executive Director of the American Bail Coalition. Tonight's show was produced by Dean Johnson and yours truly. Be sure to join Your Legal Rights again next week, Wednesday at 6. And make a note for this one in your calendar. In his book about the 2020 election, Amherst professor Lawrence Douglas asked the question, Donald Trump, will he go? Professor Douglas's book effectively predicted the Capitol insurrection. Next week, we will ask Professor Douglas the following question, Donald Trump, will he return? Again, a big thanks to tonight's guests, and our thanks to all of you for joining us. And at the controls, Damian D. Minor, I'm Jeff Hayden. Good night, and stay safe.